Okay, this lecture is a continuation of Chapter 7. We're going to be talking about international law specifically in this lecture. Now, international law is an interesting subject in that it's considered in even today somewhat primitive system, but still evolving. And the primary reason for that is because of this concept of anarchy, where we do not have a formal global rule-making legislative process. We don't have a global president with an executive branch that enforces the international laws. We don't have a global Congress to make international laws. So what has to happen is it evolves over time from customs or various agreements. And as we'll see in more detail here later, there's little or no established authority to judge or punish violations. So therefore, sovereign states, have to come together and rely on what we could call self-help in international law through various mechanisms. One, of course, is reciprocity, where I will treat you as I would want you to treat me, that sort of thing. So that does bring a lot of action for international law and justice. Also, coming together as a collective action is another mechanism through which we can create international law, and then converging international norms, whether it's over how we treat people, human rights, or even some of how we transact our business, things like that, that lead to this still somewhat primitive but evolving nature of international law. Now, the so-called father of international law, Hugo Grotius, came up with a lot of work talking about navigation on the seas, and this gives you an idea of whoever's in charge at the time does tend to dominate the literature, because the Dutch pretty much controlled world trade at that time, which is enabling Grotius to become an authority on the subject. Now, we've already talked about the Treaty of Westphalia that established the concept of sovereignty way back there at the formation of the modern state. But that also has a section in it that specifies that treaties between these sovereign states are to be observed. And then a very influential work in the 1700s called the Law of Nations. This gives you an example of how our natural resources in the environment is somewhat of a common impetus for international law. For example, in this particular work, we're talking about the nation has sovereignty over the river in its territory, but the quality throughout that river remains common, because that river could go through several different countries, and the downstream state has to rely on the upstream state to provide them a quality river. So that was some early developments in international law. In 1920, the League of Nations was formed. This was, as I mentioned before, Woodrow Wilson's somewhat of his inspiration. He helped get it going there in Europe post-World War I. However, it was rejected by the U.S. Senate. And as I mentioned before, part of the reason why the League of Nations was somewhat ineffective prior to the World War II is the U.S. not being involved in it. However, it did set a very important milestone here that established what was called the Permanent Court of International Justice, which was the first major dispute settlement mechanism in the modern world. And then that was fine-tuned, upgraded in the United Nations Charter, which we just talked about in the previous lecture. While the United Nations did recognize the sovereignty of the states and the equality of the states, they also established the International Court of Justice. And so that is another part of the UN that we've somewhat autonomous, but another part of the UN that we talked about earlier, and we'll talk in more detail about the ICJ, International Court of Justice, here in a minute. Now, as far as the roots to international law, as to what they are based on as they were evolving, we're talking about three basic roots and how they have progressed in chronological order, so to speak. The ideological or theological basis of international law was clearly early on when we were ruled by religious doctrines, that it was divinely inspired, somewhat undemocratic and dogmatic in nature, that had to really comply with what God wanted you wanted to do. And then we progressed on, particularly during the Enlightenment era. We had the naturalist roots of international law, where we're looking at certain rights bestowed upon us by nature, such as life, health, liberty, property. The concepts of John Locke and his cohort, so to speak, were rooted in this naturalist concept of law that starts to grow, still rooted in the fact that God is responsible for nature. And also, the naturalist root is somewhat vague in that how do you define what nature is, or what nature has particularly a right for us to do. And then it did give somewhat of an emphasis on individualism, which could hamper international cooperation. But now what we have today is what is considered the positivist route to international law, based on our customs and our practices. And as we evolve as human societies, the law tends to be determined as by what society wants. As society gets more populated and more complex. Now, as we see, as we're trying to determine international law based on what we want, as we grow and get more complex, you can see how that could potentially legitimize previously immoral behaviors as to what was considered illegal before, and then we progress and say, well, that's no longer illegal or immoral. So that's kind of where we are now. Now, as far as the basic sources of international law, there's several different sources that come over time to be established as an international law. And of course, treaties is one of the primary roots of international law, where the states come together, and since the states have agreed to that, they observe it in order to maintain their credibility. The UN Charter is the kind of the root of a lot of these treaties. It's very broad and far-reaching, so that it includes all of humanity to come together and make agreements that could eventually come into law, such as the 1949 Geneva Conventions, where the laws of war were established. We'll talk about those at the end of this lecture. We also have the source of custom, as to what are the practices that human beings do over time that become accepted and codified. And so, as we saw with our positivist concept of law, there's the need for society to consent to this as we progress, rather than it being bestowed upon us by some divine doctrine or natural right of God, that sort of thing. More sources, we're looking at general principles that human beings can all agree on, such as certain crimes like theft, murder, and these translate to international behavior. And there's a lot of human universals out there. We've touched on a few of those already, that regardless of what society you were socialized into, there are human universals that seem to be common to all these societies. And then, of course, one of the major general principles that was established as we formed the modern state is that concept of sovereignty. And then in particular, the violation of sovereignty is, you could perhaps argue, is probably the only hard and fast rule out there in the world today. And it still gets violated at times, in particularly by a major power. So therefore, makes it more difficult to punish that or enforce that. Legal scholarship is to where the judges can rule and Even Supreme Court justices can come down with rulings that may have an international influence. We'll talk about that here in a minute. And of course, the international courts can make rulings that set precedents. So this concept of case law means that whenever a judge makes a decision, well, all the other judges within that court's district have to abide by that. And of course, the concept of judicial review, famously in the United States, the Supreme Court can strike down a law if they find it unconstitutional. Similarly, an international court, if for example, the European Union, which we'll talk about in more detail in a next lecture, that if the states are abiding by a international court, well, then that court could overrule a national law, strike down a law. So this is another international case law, so to speak, is another source. And then we've already talked about how representative assemblies, such as the UN General Assembly, can come together, create resolutions, and that provides the genesis of international law. We've had several examples out there that have got their start as resolutions, such as the UN Convention on the Law of the Sea. Now we're going to get into the enforcement of international law. And as we'll see here in a minute, this is quite difficult, and one of the, I guess you can say, hindrances of the evolution or the effectiveness of international law is the difficulty of enforcing it. So what we have to rely on, again, we've talked about some of this with this self-help concept, that some enforcement has to be done by reciprocity and collective action between states. So there is some kind of, I guess you could say, a cost to doing something that is against the norms of the international community. And so there is some legitimacy to a reprisal against some action that was considered illegal. And one of the most common things to do, probably one of the first go-to actions that really has some effect, are sanctions, to where the international community has to kind of come together and agree to punish the violator. And so the United States has spearheaded several sanctions against Russia, against Syria, see some now against Venezuela. We've had an embargo against Cuba for decades. So the embargo just means the ceasing to use their products, or stop trading, to withhold their investment, or to seize assets. Those are things that we could do to sanction another country who has violated some international law. Now, another thing that what can happen over time is that states can create expectations of what is legal behavior, and then people start to conform to that, and then it becomes somewhat of a reason for not violating it. And as we've seen with the resolutions that evolve into law, we establish workable rules that, for example, the World Trade Organization has rules that you have to comply to in this trade regime, and violation of those rules could result in some form of enforcement, such as some reciprocity of states being able to return that behavior to the violator. And we'll talk about that in more detail when we get into the trading aspect of the class, as to the various things that states do to get an advantage on trade. So as we've already talked about, it is difficult to enforce international law, and so therefore, as a result, it's somewhat more difficult for states to adhere to it when they know that it can't be enforced effectively. So what we see here, we'll talk about several things here as to why it's difficult to enforce international law. And some of it is because that in order to enforce it, it depends on national power. as we'll see here in a few minutes, the United States, because it is very powerful, its own national courts may actually reach out and rule on something that has international implications. And only the very powerful states can really do that because they have the potential perhaps to back it up with their economic power, military power. But most states aren't near that powerful, and so if the major powers don't feel like it's worth enforcing, then it may not get enforced. Now, the collective action option requires collective agreement, and as we've already talked about in the previous lecture, it's very difficult just to get those 5 permanent members on the UN Security Council to agree, much less 193 countries out there in the world. So as you can see, that is extremely difficult because not all states may care enough to get involved, or it's not in their self-interest. Hence, that sovereign self-interest. We've got to take care of our own boundaries and our own people. And again, as I've mentioned, there's disagreement among the major powers. And we also see that international law is not as effective in the things that matter the most to people, such as national security and even our own domestic economy, because international agreements and international law could even interfere with our domestic economy. And when it comes to taking care of your national security, the states are pretty protective about that, particularly the United States with a huge military that feels like that it can take care of its own problems. So what we see is that international law is more effective in these low politics, that do include trade agreements, but now as you can see, we're seeing some backlash against trade agreements that they may not be as beneficial to our domestic economy as they may have been expected to be. Now we'll talk about that in more detail later on in the economical section of the course. And we've already mentioned how the environment and natural resources seem to be pretty effective in influencing international law. So as you can see, things like maybe human rights, health issues, environmental issues, those seem to be more readily delegated to international law, just like they were delegated to international organizations. However, not quite so much on the high important items. More on the difficulty of enforcement. Compliance to international law is mostly voluntary. And so what that means is that once the international court is established, and we'll talk about a couple of them here over the next couple of weeks, that once that court is established, the states have to agree to abide by it. They actually have to agree to that they were going to accept that decision. So what we have here, along with voluntary compliance, that then leads to fairly limited jurisdiction, that the international court can make a ruling, but it may not have jurisdiction over a large area of the world that does not recognize it or is not a member of that court. So again, sovereignty remaining a barrier here, and just like any other court, courts don't typically reach out and grab people. That's up for the executive branch enforcement mechanism, like the attorney general and the police force, and then they bring it to the courts. So similar to that, states have to submit their legal disputes to these courts. So if they don't recognize that court, they're not going to submit any disputes to it. It's also a matter of willingness for the states, and there's several reasons, and that we can even point to the United States, which is really has not been a part of the International Court of Justice system and has not even recognized the International Criminal Court, even though the United States does agree with that concept and supports their idea. The United States is big enough to where it may not want international law to supersede our Constitution. So that's a pretty big deal, because what happens is that when you make an agreement to an international law, even a treaty, you may have to come back to your Congress and say, okay, Congress, we have agreed to this treaty, or we have agreed to this court, and we're going to abide by this court's ruling. Well, that may require you, Congress, to change a law in order to comply with that. And in a lot of cases, a sovereign country's Congress may not want to do that. And we've already talked about the fact that the United States has got so many soldiers and diplomats and troops out there in the world in many different countries, and it does not want their citizens overseas subject to international law. We'll talk about that in a little bit more detail when we talk about the International Criminal Court. One of the reasons why the United States did not ratify that treaty for the International Criminal Court was partly this reason right here, is that we did not want our soldiers or our citizens overseas to be subject to an international court. We would rather take care of that ourselves. So let's talk about the International Court of Justice. The ICJ, as we mentioned before, is a fairly autonomous arm of the United Nations. And so the International Court applies only to the states and their disputes against each other. It's not a court for individuals to bring claims against somebody else. It's one state disputing something against another state. And as we've already talked about, states may want to delegate relatively minor issues to the court and then handle their big issues on their own. The court has 15 judges with 9-year terms, and since it is an arm, or was originally established by the UN, each member of the permanent 5 on the UN Security Council has one of these judges. So we'll show you how that is somewhat of an undemocratic element, you might say, as well. Now, the ICJ relies on the optional clause that the states have the option to comply with their jurisdiction. And as you can see, 2/3 of the states in the world have not agreed to jurisdiction by the ICJ. So you can see right there, that's one of the reasons why it's primitive, but yet still evolving. And as I've already talked about, the ICJ is going to arbitrate issues of relatively less importance, commercial disputes, border disputes, things like that. The book gives you a case study on page 220 of Argentina versus Uruguay border dispute. Here's the map of compliance. And so, as you can see, there's a relatively small group of states here that totally accepts compulsory ICJ jurisdiction. And there are more states, here you see in the darker blue here, aquamarine blue here, whatever, is several more states accept ICJ jurisdiction. However, they have some restrictions, and we'll talk about U.S. here in a minute. The United States withdrew from the compulsory ICJ jurisdiction. And as you can see, a large chunk of states have not submitted to ICJ jurisdiction. So that shows you right there that they've still got an uphill battle for a comprehensive system of international law. The current judges on the ICJ, the names aren't important. I just wanted to show you that, as you can see, a few states here I have in bold. Well, this is somewhat ironic, I guess you could say, is that these states have judges on the ICJ, while at the same time, these states are not compliant with ICJ jurisdiction. So again, that doesn't take anything away from the competence of these judges or perhaps even their impartiality, but it is kind of a paradox that you've got judges on the ICJ from states that don't comply with the ICJ. Now, as far as the adjudication hindrances, again, the effectiveness of the ICJ is subject to the fact that it's difficult to enforce. The ICJ does not have an executive branch that is parallel to it that can go out there and enforce these rulings. And we've already talked about the jurisdictional limits that that the ICJ has to deal with. Now, there's a couple examples of the U.S. has kind of progressively retreated from the international jurisdiction. Back in 1984, the court ruled against the United States with respect to charges of the involvement in Nicaragua with the funding and the support of the anti-communist rebels there. And at that time, because of that dispute with the ICJ, the United States then withdrew from that optional clause back at that time. And then fast forward up to 2003, during the War on Terror, the ICJ rules against the United States. 51 Mexicans had not been given access to consular officials, so that was part of the tightening up, the unilateral actions of the United States tightening up in order to try to fight the War on Terror. And at that time, the United States even withdrew from an earlier convention on how to treat foreign diplomat or foreign citizens that are held. And so we've, during the previous administration, or I guess I should say the Bush administration, we withdrew a little bit more from the ICJ, and that has not really been restored, but we have backtracked a little bit and become a little bit more multilateral and accepting of the idea of international law and justice. But again, we're the superpower, the biggest dog on the block, so we still have the, I guess you could say, the opportunity to go our own way if we choose to do that. And so what we do see is that is another counter to the ineffectiveness of international law. We're seeing more national courts trying to kind of fill that gap. And so we see that national courts are somewhat attractive to international cases, because if a national court makes a ruling, then it actually has an enforcement arm. It's got a military, it's got police forces, it's got an executive branch, things like that. It's got monitoring agencies. So the judgments are more enforceable by the state's legal system. Now, as far as how far that enforcement system can reach out beyond its borders, that's another story. But the book gives some interesting examples there as to how, as long as it's happening within those borders, the state can still enforce it to a certain degree. And of course, with the national courts, individuals and private companies can pursue complaints and actually get compensated, whereas it's going to be much more difficult for them to go through the international court and have that compensation be enforced by somebody. And of course, as I've already mentioned, the ICJ only handles disputes between states. So therefore, if you've got an international situation that individuals can claim, then the national courts might be a better route. And I've already talked about that agency called UNCTAD in the United Nations, where companies can file claims against states, and states can file claims against companies, which where there may be an issue over assets being seized or breaking of promises of corporations to states and vice versa, things like that. Now, another example of how this works is that the Belgian courts were given jurisdiction over the Geneva Conventions to rule on these laws of war. Now, some other examples of using national courts for international cases. We typically see that the national court, its jurisdiction technically ends at that border, but there have been some attempts by the U.S. Supreme Court to extend our sovereignty out there in the world a little bit. Recently, there was a case against Argentina where the Supreme Court ruled against Argentina in order to try to get compensation from people that were owed money from their massive debt debacle about a decade or so ago. The court ruled against Argentina and said they were still liable for that to the people that did not comply with their bankruptcy action. And of course, extradition, this requires agreements between states, and it's a state may actually ask for somebody to come back, but if there's no legal agreement between states, that's difficult to bring people back. We're also seeing some immigration laws that are passed by national courts that do have some international ramifications. We've already talked about just briefly the travel ban on certain immigrants from certain countries, and how the courts are ruling on that, because even though they're basing their ruling on harm to individual U.S. states, it does have far-reaching ramifications. Now, another example of how U.S. legal system might reach out a little bit was the example of the United States Justice Department charging FIFA, the international soccer organization, with racketeering, fraud, soliciting bribes. And that is an international organization. So you ask yourself, well, how did the Justice Department, I guess you could say, validate their ability to do that? Well, one thing, FIFA had used U.S. banking and wire facilities to distribute payments, which were bribery payments, or to launder money. So that put it on U.S. soil. Some of the schemes were actually planned in meetings that were held in the U.S., so that gives the United States more authority to go after them. And then there were some instances where the taxes were owed to the United States on some of these transactions that were evaded. So again, the United States felt like it would have a very justifiable role in going after these activities by an international organization. So now that brings up your assignment for this particular lecture. So we've talked about how national courts, particularly in the United States, have made rulings that have international implications. So you clearly want to read those pages on 221 and 222 that talks about international cases in national courts. And so what I want you to do is to perhaps Google out there a little bit, take a little kind of a rudimentary search, and find a Supreme Court case. It doesn't really matter how old or recent it is, but find a Supreme Court case that could be interpreted as an international law case. So don't necessarily need to elaborate. Just find an example how this particular court case or this ruling could perhaps be also handled in an international court, for example. So post your response on the discussion forum for this particular forum for Chapter 7, International Laws. You'll see there on Moodle. So I'll remind you of that again here in a minute. But that's your assignment for this particular lecture. Now let's expand a little bit and talk more about some more, I guess you could say, accepted laws of diplomacy that have evolved over time. Embassies have been given in each country diplomatic recognition. However, the host country's laws cannot be forced within that embassy without the home country's consent. So that's kind of a give and take. But on the other side of that, the diplomats have immunity from the home country's laws as long as they're in the embassy claiming immunity. They can be shielded from arrest. And also diplomatic pouches, which are private or property of that host country in the embassy, those pouches cannot be seized or searched as well. And so that's why during the Cold War you would get a lot of spy versus spy intrigue at the embassies, where the embassies were perhaps bugged or had secret passageways in and out of them, things like that. Embassies also can be subject to terrorist attacks as a symbol as much as anything, but there have been some deadly attacks. Al-Qaeda first came into prominence during their attacks on the U.S. embassies in Kenya and Tanzania in 1998, and then the terrorist attacks in Benghazi in Libya in 2012 also created a lot of attention that even had ramifications for a few years thereafter as far as the political I guess you could say, political accusations, things like that. But the embassy could be somewhat of a target uh, in that region. Now, the just war doctrine is, again, we're talking about agreements between states, and that non-state actors are not necessarily going to be looking at these things and saying, oh, we have to comply with these rules. No, and that's why it's so important in the world to have that credibility of being a sovereign state, and that you're going to comply with these international rules, such as the just war doctrine, where wars of aggression are determined to be illegal. And the violation of sovereignty, which is the only hard and fast rule out there in our global system, is a no-no. And clearly the reason why the Gulf War came together fairly quickly and was relatively successful was because the Saddam Hussein had violated Kuwait's sovereignty, and everybody had kind of come together as a consensus to push Saddam Hussein back in his territory. Now, again, you could certainly argue that when a major power does that, such as when the United States invaded Iraq yet in 2003, justifying it for several reasons, particularly in the aftermath of 9/11, well, then the international community can complain, just like the UN did not go along with it. Russia and France were ready to veto a Iraq War resolution. So you can see there is payback for that. There was some consequences to the United States unilateral approach. We had some backlash on that. The war did not go very well. And of course, Russia's actions in Georgia have been sanctioned. Their actions in Ukraine have been sanctioned. But again, when a major power violates somebody's sovereignty, it's a much more difficult issue to deal with, because you certainly don't want to get into a major ground war or even a potential world war between major powers. Now, what makes it a just war? You're responding to this aggression or a repelling attack or self-defense. Clearly, reasons for getting involved in a just war. You could perhaps argue that in addition to the Gulf War, the last true just war could have been defined as World War II, where we were attacked by Japan and then Germany declared war on us. So we also considered it legitimate authority to bring justice or peace to the conflict, or in this case, last resort. And the United States really tried to stay isolationist up until Pearl Harbor. So again, somewhat of a last resort there for a just war. There are also some agreed upon concepts for the laws of war, restricted to the combatants, protecting civilians, and that's why terrorism is so insidious, because it targets civilians. There's no attempt to comply with any consensus or laws of war. Another thing, that your force is proportional to military gain, in that overreach of military force or disproportionate use of force is considered unnecessary. Again, in war, we're looking at uniforms and insignia in order to separate the combatants, and particularly to designate civilians. And again, in guerrilla warfare, that kind of goes out the window, making it a lot more difficult, as we talked about before. And the United States did try to contract out some private forces, and that kind of went south on us a little bit, particularly during the Iraq War, when the private contracted forces got involved in a skirmish that turned out relatively badly. So the United States rescinded that legal waiver to move back away from the use of privately contracted forces back in 2008. Again, the treatment of prisoners of wars is an accepted rule among sovereign state combatants. There's a special role for the International Red Cross, and that states to respect that neutrality to assist the civilians and the prisoners of war. Again, this is why this is so important, because if you're not complying with the laws of war, it's going to be considerably more messy and chaotic and destructive. And those are the kind of the wars that we have to worry about more so than anything right now, because the actors, the combatants, being are not representing a state in most cases. And when they are, such as in Syria, the state actor is behaving just as badly as the non-state actors in many respects. And then, of course, the laws of war do not abdicate the moral responsibility of the individual, such as in the World War II, when the Nazi Holocaust, the officers perpetrated genocide against the Jewish prisoners. They were not allowed a defense of just following orders. The individual still has to be held responsible for his actions. All right, so that concludes the video lectures. So don't forget to respond to the assignment that I talked about earlier when we were talking about the national court system. So post your response on the Moodle discussion forum for Chapter 7, International Law. And the deadline for that is midnight Saturday, March 25th. So if you miss that deadline, you'll be counted absent for those classes. So you don't want to miss that.